All right, that's why United Taxi Association in the Northwest says many of their members whose vehicles are financed by the SA Taxi Development Finance are subject to high rates of vehicle repossessions due to alleged unscrupulous business practices. And one of their members is at loggerheads with the SA Taxi Development Finance after his taxi was allegedly repossessed and damaged despite him having paid up his arrears. We've wrote in Annaline Poel, who's the Debt Rescue COO, in order to help us further unpack the implications of loans and responsibilities, rights that consumers have pertaining to such a huge vehicle as well as other loans. Annaline, it's great to have you on the show. Welcome. So I remember during COVID, right, as a consumer activist, being so inundated with inquiries of vehicle or home loan debts and the after effects there of being laid off work. I mean, these were trying times, Annaline, and I think at that particular time, a lot of South Africans that did have big loans like your vehicles had to really familiarize themselves with the law and what you can and cannot do. But it seems some did not use this opportunity to self-educate. So please briefly talk us to what struggling vehicle owners like the taxi owners in this instance who are getting their vehicles repossessed for non-payment can do. Let's start with the options as well as responsibilities before you actually fall behind on your debt.
Good afternoon, and thank you so much for having me. I think you absolutely hit the nail on the head in terms of education. I think it's so incredibly critical that when we enter into any form of agreement, we understand what kind of agreement we are entering into and what the rights and responsibilities are of all the parties. So, for example, are you entering into a credit agreement? If it's a credit agreement, if so, what are the rights that you have? What are your responsibilities? If it's not a credit agreement, the same. What are your rights? What are your responsibilities? It's so fundamental for consumers to understand what their rights are, but also what their responsibilities are. Because as much as we do have rights, we do have responsibilities as well. And obviously that's reciprocal. And there is legislation that governs all of this. But ultimately, if you have a credit agreement as defined by the National Credit Act, then you fall under the right of having being able to apply for debt review. Mm-hmm. And that is a really important right for consumers, especially, I mean, we speak of COVID, but we are still sitting with the after effects of what's happened subsequent to COVID. And that is a very, very difficult and tight economy. Consumers have not recovered. In quite the contrary, it's even more difficult for them out there at the moment. Cost of living is massively high. Debt repayments are incredibly high. So really, really understand your rights, read your agreement, make sure you understand the T's and C's ultimately.
Absolutely, Annaline. And even going that debt counseling or debt review route, you still need to be careful because there's still unscrupulous service providers in this regard. And sadly, in this case, Annaline, I mean, the chances then of the debt being written off are very slim, right? Depending, of course, on the length of time. And most importantly, I suppose, how much you still owe the bank. But listen, when we advise consumers, we always say, speak to your debtor, and failing which, then a financial advisor who can see how to salvage and recoup some of your revenue. And if you still have this problem, but there are such individual cases that it's actually quite impossible to impose a blanket legislation. I know you spoke about policies there in terms of the CPR as well. Yet lenders, to be honest, never want to sometimes hear of any alternative payment plans when you actually start defaulting on your debt. So what can such over-indebted consumers do legally to try and maneuver from that particular situation?
Well, that's why I say, firstly, start by familiarizing yourself with the content of the agreement that you have. Mm-hmm. Is it a credit agreement in terms of the National Credit Act? If it is, then it means you get the protection of the National Credit Act. And the protection of debt counseling is what comes in. Yes, you can try and speak to your credit providers, absolutely. And some of them may be willing to make some sort of agreement, whether it's long-term, whether it's short-term, to try and assist you. But ultimately, if it's a credit agreement in terms of the National Credit Act, one of your rights is to obtain the help from a debt counselor who can restructure your debt, give you that legal protection that comes from the National Credit Act. Mm-hmm. And If you make an agreement because it's not a credit agreement, in other words, it falls outside of the ambit of the National Credit Act, make sure that you get it in writing and adhere to it. But if it falls under the National Credit Act, absolutely, the debt counseling process is there to protect you. But same story, you have to, ensure that you comply with the requirements of debt review, meaning you must still make your payments. You can't miss payments. Your debt's being restructured, so commit to the process to find that solution, to give you that financial relief and that legal protection by doing your part, which is making your payments every month.
Annaline, let's also call out some debtors, because I have dealt with some and they will basically not give you the second of the day should you try and negotiate with them. Let's talk about legally. What can and can't they do? Starting with the fact that their repossession agents cannot harass individuals or even take a car without a court order.
No, absolutely not. So, look, ultimately, you have a credit agreement. If it's a credit agreement under the National Credit Act, and there are specifically with credit agreements very specific processes that need to be followed before a vehicle, for example, can be repossessed. So, if it's a credit agreement, it falls under the ambit of the National Credit Act. They have to issue you a document called in the industry a Section 129. It's Section 129 of the National Credit Act, whereby they advise you they are going to proceed with legal action if you do not make contact with them, or alternatively seek the help of a debt counselor. And then obviously, if you do not comply and do not seek any form of help, they've then got to go to court. They've got to obtain a court order, and ultimately get an order that says that they are allowed to repossess the vehicle. Without that, they cannot legally repossess it. What can happen though is, for example, they can hand it over to a collections agent who can approach you and possibly ask you to surrender the vehicle voluntarily. That's called Section 127 of the National Credit Act. And if you do that, that in essence means that you have voluntarily handed back the vehicle to the credit provider. And then, unfortunately, it's very difficult, for example, to renegotiate to get that vehicle back. Not impossible, but it does make it more difficult. So hence, understanding your rights, understanding your responsibilities, and understanding that make sure if somebody says they're there to repossess your vehicle, that they have an actual court order. It will usually be, served by the sheriff, and read through the documents before you hand over anything, and make sure you understand what it is that you are signing.
But Annaline, there's also, very naughty consumers who will think they know about the prescription of debt, right? But with cars, it hardly ever happens, as I mentioned earlier in the previous question. But the car potentially the asset still belongs to the bank up until you've paid your last installment. So I think in this case, people were actually getting, angry that the bank actually managed to track them and actually repossess a vehicle which they thought the debt has long prescribed.
I think it's very, very important that people understand how the Prescription Act works. And obviously, depending on the type of debt, there are different periods when it comes to prescription. But, like on an unsecured debt, for example, it's 3 years uninterrupted, where you haven't paid, you haven't acknowledged it, you haven't come to any agreement, and no legal action is taken. Then the debt has prescribed. But it's really, really important to understand that debt doesn't just prescribe, it doesn't just go away. And a lot of people I've recently seen say, oh, but it's not on my credit report anymore. That doesn't matter. If there are set periods, and it has to fall within those periods and with those specific, criteria. And it's very easy. You can go and Google prescription, prescription of debt, and you'll find, all the legislation and a lot of websites that will explain exactly how it works. But really, really critical to understand. If there's an asset involved, most likely that they're going to be searching for you. And remember that it's also part of your credit agreement. If you, for example, move, you have to keep the credit provider updated with your current address, because they are under the obligation to serve you with the necessary documents at the address that you provided. And if you did not update it, then unfortunately that is your responsibility that you did not follow, and therefore it puts them in the position to proceed with the action, because they are working with the information that you provided ultimately, and you did not keep to the contents of the agreement.
Bad news. Well, everybody must watch out. Annaline, thank you so much for, of course, those pros. That is Ms. Annaline van der Poel, the Debt Rescue COO, weighing in on car loans as well as consumer responsibilities, should you, of course, fail to service your debt. We're going to take a quick break. I'll be back shortly.